workforce box to Tanya Vyhovsky. Senator Vyhovsky. Okay, so welcome everybody. We're here in Senate Economic Development, Housing and General Affairs, and it is Wednesday, April 12th, and we are beginning with an introduction of a bill that is in our committee, S-127, that Senator Vyhovsky has introduced. And Tanya, please come join us. Senator Vyhovsky is going to chat us through this bill, and then we're going to turn our heads to sports betting.
Perfect. Well, thank you for having me. For the record, Senator Tanya Vyhovsky, and I am the lead sponsor on this bill. This bill, for me, this is a bill I worked with a coalition of people on throughout the summer and fall, and is really around sort of grounding our cannabis market in social equity. There are a bunch of provisions in the bill. It's actually been a little while since.
So this is the cannabis bill.
It is a cannabis bill.
So as we take up the cannabis bill, it's a perfect moment for us to be hearing about this bill. So thanks.
Yes, well, thank you again for having me. So there, like I said, there's a bunch of provisions in the bill. It's been a little while actually since I've looked at the bill. Thank you, that would be really helpful. So one of the really critical parts in this bill for me is around how we're using the cannabis excise tax. So currently 30% of up to $10 million of the cannabis excise tax goes to the health department for prevention. And this bill would allow that 30% to go to prevention, treatment, and harm reduction. So it expands that a little bit. It also earmarks 20% to go into the cannabis revolving loan fund for business, for social equity business startup, and 10% that would go to disproportionately impacted communities from cannabis prohibition. I heard a lot as we were talking through cannabis in the last biennium from people who were saying, well, I was harmed by cannabis prohibition, but I don't want to start a cannabis business. What about me? There's a pretty complex metric in here trying to sort of identify what are those communities, because it's hard to know. So there is a metric around the identification based on free and reduced lunch use, based on incarceration rates, and there's a bunch of different pieces in there that try to get at how do we capture communities that may have been disproportionately harmed for community development coming from our legal market. So that's one piece of the bill that is really important to me. That's actually where I started on this bill, and then I brought in a bunch of other people to talk through other aspects. This bill also looks at consumption in any place where cigarette smoking is legal, really thinking about people who maybe rent and can't use cannabis at their homes, or people who are traveling here to purchase and can't take it across state borders, and how do we allow them to take part in our legal adult use market. It also has an aspect that would allow for social event licensing. So like we do beer festivals, and this would allow for social event licensing.
And the commissioner of DLL walked in just as you were beginning.
Excellent.
So a special events permit.
Yes, as well as a delivery license that would allow for people sort of both social event and delivery are kind of lower barrier entry into the market, as you don't need as much capital to stand up a physical standalone space. So again, this sort of gets at social equity in two ways. One, through actually earmarking cannabis excise tax towards supporting business startup, but also creating lower entry businesses that people who maybe don't have that capital and our social equity applicants can engage with. So delivery is one aspect of this bill in section 5. And special event is section 7. It also, and I'm going to skip over a little bit this part because Senator Starr really worked on the ag pieces and is continuing to work on the ag pieces, but there are some aspects here that would make it a little bit easier for growers to sell either direct to consumer or expanding our ag exemptions to people. But again, I'm going to let Senator Starr deal with that because he is much more adept at navigating all of the ag aspects than I am. And
we have delegated the ag aspects to their committee, and they started testimony on it yesterday.
Yes, this would also expand expungement to higher levels of sales, given that we now allow for sales. It would So while someone who previously may have sold or dispensed cannabis without a license, there was no license for them to have, but now those amounts are allowed to be sold in the legal market. So it expands expungement to those dispensing crimes.
Can I ask a question?
Yes.
Yeah.
So, do we have that information in the record to be able to do those expungements?
So that was a really actually probably the trickiest part of writing this bill is trying to figure out how to thread that needle. And so, yes, we think so. We think we wrote it in a way that we would be able to capture more expungements. But because the criminal aspect of cannabis has changed over time, and the different coding within the system for which crime it is has changed up over time, Michelle and I worked really, really hard to try and write this in a way that would capture as many people as possible. And in all likelihood, we will probably still miss some people because of just the shifting nature of the legal market.
Because it might just be plus something, that it's more than something in the record. And Michelle is.
Michelle Childs was the drafting attorney on this.
You
bill.
met her in the bill introduction.
Okay.
She and where she was sitting immediately to your left.
Okay. Thank you.
And then this bill also, the last thing it does, at least it's supposed to do, but I'm not seeing it in here now, is so right now cannabis consumption is a blanket term. It doesn't matter if you're smoking cannabis, if you're vaping cannabis, or if you're using an edible.
Right.
And this would differentiate smoking and consumption in that way and an edible. And that's largely to help our renters and to really acknowledge that the impact of smoking in an apartment is very different than the impact of taking an edible. And so this would allow landlords to say, no, you can't smoke, but it would not then prohibit someone from using an edible in their apartment. And currently the onus of asking of whether or not you can use cannabis in your apartment is on the tenant. The tenant has to ask permission. And I would really advocate that we should flip that like everything else and put the onus on the landlord to put a prohibition.
Can I ask another question? That's interesting. So that's our current law?
Yes, it is. It's problematic because we don't ask about alcohol consumption in people's apartments. I mean, it is. We do have a smoking. I mean, there is the smoking issue, but we don't, in terms of internal consumption, we don't prohibit. And the other one with alcohol, or we don't actually. I mean, it's illegal.
Could your landlord say, I don't allow drinking in my building?
I suppose that I have no idea if they could.
I don't know.
I don't think they could, but we can find out. That's why we have legislative council. We will ask, but I can't imagine.
Well,
I
some
think they can-
shelters.
That's a different
Shelters
situation.
absolutely do.
Yeah.
There's no smoking of anything or drinking of anything.
I think
Sorry.
they can also
They-
say that in basements. Because there's extra danger and people can have large gatherings in basements. So a lot of people can prohibit drinking in basements or congregating in basements, period.
Really? Huh.
Burlington has those kinds of issues, but
So that's why there's those two pieces is sort of, like I said, differentiating out. So a landlord could say, no, you can't smoke anything, but that would still allow for edible consumption. And then again, it is not in this bill because we really felt like this was more of a renter's rights issue, but I would really advocate for transitioning from the onus being on the renter to ask permission, and instead, just like everything else, putting it on the landlord to put it in the lease that like, no, you can't smoke. And that's my very brief walkthrough of this bill.
Well, thank you. This is our understanding of the cannabis bill is that this year is and as you know, we have a very modest amount of time to work on,
Yes.
which is our biggest challenge right now, because what you're proposing, some great ideas, but all will require some thought.
Yes.
And what am I saying other than that? I think that is, I really appreciate you bringing some of these, and I think we're going to have to figure out with the Cannabis Control Board what is housekeeping and what is new policy, and how much we want to integrate and how much time we have to integrate new policy. So,
I completely understand, and if I had to pick through this bill, the things I think are really the most critical as we move forward, making sure that our cannabis
so that's
market.
my question for you.
Yeah, as
So-
we think about moving forward, making sure our cannabis market is really grounded in social equity, I think the transition of some of those excise tax monies to social equity applicants and communities is really critically important. You know, we stood up that fund and put, I think, $500,000 in it, which we know is just not adequate. So that is a piece for me that is really important. I think either delivery or social event, creating at least one lower barrier entry point for people. And this way the social event licensing is written is based after California law and does leave a lot to rulemaking. And then the ag pieces are the other pieces, but I'm
Right.
giving, Bobby is gonna.
So do you know if Bobby's weighing in on those now?
I spoke to him yesterday and he said he has taken up testimony and is prepared to come and talk to you when you're ready for him.
Oh, because I don't think they finished yet.
They may not have finished
Yeah.
yet, but he does
Okay.
know that I've given
So,
complete ownership of that to him.
okay, because the bill is in our committee at the moment. So we can look at giving him those pieces of the bill, those sections of the bill, the ag sections
Mhm.
for him to look at. Okay, great. This is terrific. So the excise tax, so from the top, the excise tax delegation and where it goes and what it goes to, I think sounds like the most important thing to start with.
It certainly is the most important thing to me. And like I said, it's where this bill started for me. That was
Okay.
my initial idea. And then as I connected with other people that are doing on the ground, because I don't own a cannabis business, so I certainly don't know what the needs are. That really came to the top as one of the
Right.
most critical needs.
Thank you. Any questions before we do not a fully radical shift, but a modest shift
Just
to
one
sports
question.
betting? Any other question? Anne,
Just
Randy, you have a
one
question?
Yeah, it's talking about funding for communities that have been disproportionately impacted. And there are a list of items as to what those communities consist of. Does that suggest that someone who is not from any of those areas at all could open a business in those areas and then be subject to a benefit because of that?
So the community development benefits were not actually meant to go directly towards cannabis businesses. They were really meant to go towards community development. And so that might mean, you know, I know in Burlington, there's the Richard Kemp Cultural Center, and that could mean that they get some of that funding. So this was really, that particular aspect of the excise tax was actually meant
Was a
to.
benefit as opposed to anything that is related to the business itself?
Correct. It was for the community and to try and help lift people up who've been harmed, but want nothing to do with getting into a cannabis business.
Great. I think, any other questions? I think great. Thank you so much for this.
Yeah.
And great food for thought, and as it were, and more to follow.
Sounds good. I'll give you your copy of
Thank
the
you,
bill back.
thank you,
Thanks for
thank
letting me
you.
have it.
And good luck in judiciary.
Thank you so much. Have a lovely day.
You too. Thank you, thank you. Okay, I think we are going to shift gears to our sports betting bill, our H-127. And I think Tucker, you're on deck, and we're going to discuss the amendments we discussed earlier this week. And Tucker has drafted the amendment, and I think we're going to talk about, yes, so I think we're going to talk about some of the changes we discussed in the bill and Tucker's amendment. Is that right? Tucker, you're on deck. Up to bat, on deck. I think up to bat is maybe more appropriate.
It's at that end of the table.
There's a little mound, there's a little diamond, or whatever we call that little thing they have to hit. What do we call that?
Baseball?
No, not a base.
The batter also is.
No, they have to land
That's
on.
the only thing they're supposed
But
to.
it's
It's a
And
good
if the
thing I
batter's
don't
at the
have a
mound,
background.
there's a big
no,
problem.
the batters, but the mound is where the pitcher is. That's higher and it's a mound. But where the batter is called something else.
The plate.
The plate, thank you. You're up.
And the box, the batter's box.
Well, whatever. Anyway, Tucker is there and we're gonna bet on how long he's gonna be here. How long will it go?
I won't take that personally. Good morning.
Good morning, Tucker. It is good to
Anderson.
see
Legislative Council, you should have in front of you both H-127 as it passed the House and a proposal of amendment from this committee. There are 5 instances of amendment.
I just want to make sure everybody has it. Do we have a, Paul, do we have other copies, Scott, for Wendy and Charles and Chris and company?
I have it.
You have it on the, okay, on our, okay, right? Just want to make sure everybody's seeing.
Okay. Starting from the first instance of amendment, and you heard background on each one of these from the department, so I won't give you
Can I
too much context.
backpedal?
Yes.
Tucker pointed out yesterday that we actually have not walked through this bill. And there is, just before we do the amendments, it might make some sense, the bill is not that long, to quickly, would that make some sense, Tucker? We're going to have another hour between 11 and 12, so we are coming back to this. We have punted our other half of the hearing that we were going to do together because the health and welfare couldn't join us.
What hearing are we doing together?
We're doing at 10 o'clock, we're doing your agenda, it's the supportive housing joint committee hearing to follow up on our housing work on disability and mental health supportive housing. The health and welfare committee could not join us for the second half, so we decided we're going to punt that and do that together. And so the second half we're going to do at another point, but we have to. We're really focusing on trying to get H-127 done before our chair is departing. So that's part of our objective.
I would find it helpful to walk through.
So I think before we do the amendments, it would be helpful to walk through. And thank you, Tucker, for pointing that out. We had jumped right in. We've done an overview with Tucker last week or the week before and with Wendy. So let's just do a quick overview and then let's discuss the amendment.
All right.
Sorry, my bad. I just forgot.
Just in case this happened, I did flag all of the big pieces of the bill.
And you were so polite. You weren't gonna say, Hal, we talked about doing blah, blah, blah. Okay.
My motto is as you wish. So as instructed, we will walk through H-127, hitting the critical components, perhaps not doing a word by word read through
for a 30-page bill. That's great.
What I'll do is I'll pause and discuss the things that are being amended in your committee's amendment as we move through.
I think that's terrific.
Start on page 1.
Cool.
In section 1301, we're working within this subchapter that deals with the authority of the department. And in section 1301, we have the definitions for purposes of the entire chapter. The important definitions that I'll point out for you, the very first, adjusted gross sports wagering revenue. It refers to all gross sports wagering receipts excluding voided bets and less winnings paid out and federal excise tax. So it's essentially everything but the standard negatives, including the tax payments and levies.
So it does not include administrative costs of the operator.
Skipping on to page 2. Quickly cover some of the prohibited definitions here. So in subdivision 9, you have the prohibited sports bettors. These are the folks that cannot participate in sports wagering by virtue of either some connection to a sports governing body. So for example, players, referees, etc., or a connection to the operators themselves, having some sort of unfair advantage or some sort of ethical or integrity connection to the sporting events that are the subject of a bet. The department itself is also excluded here, the department and its employees, since they are the offerer and the participant in the sports wagering market.
Does it exclude, other than persons 21 under, does it exclude anybody who has become a problem gambler so badly that they are so that they're identified in some capacity?
We'll get to self-exclusion later, but in general, and this is true for all of the sports betting states that I'm aware of. Exclusion is something that an individual does independently through a process that's available simultaneously through the operators, and in our case, as a control market, through the state as well. So an individual voluntarily says, I would like to exclude myself from wagering for an indefinite period of time, for shorter time in duration. I don't want to bet for the next 90 days.
And is that then identified somehow so that the app would stop them from placing a bet?
Yes.
Okay, great, thanks.
And
Is there any potential legal situation in which, let's say, a court could order someone to stop?
Yeah, I was thinking of
I think the
DUI.
classic situation is someone engages in an embezzlement, and one of the motivations for it is a problem with gambling. And could the court, as part of the sentence, say that you will?
I would assume that this can be the subject of a lawful injunction, just like any other regulated activity.
You know if that's
So
happened in other states?
I'm not aware of that, so I can't give you any examples. But you can have injunctions ordered by a court for almost anything.
But just to follow up on that, so it sounds like it could be enforced. Technically, if not legally, but it technically can be enforced.
Yeah, I think in Senator Brock's situation, it's a little bit more clear where there might be, for example, some sort of criminal or unlawful activity attached to the wagering, where the court would say we're going to enjoin any further wagering conduct. But again, that would likely be enforced on the individual
Okay,
player.
thank you. Thanks, that's helpful.
In subdivision 10, we have some of the prohibited sports events. This definition is going to determine the scope of the types of events that can be the subject of a wager. A little bit later, I'll quickly touch on the department's authority to approve categories of sports events and types of wagers. But here you have default statutory prohibitions on the types of sporting events that can be subject to a wager. By and large, these are going to be your collegiate sports events, in which one of the participants is a college team of an institution primarily located in Vermont. There's an exception that this does not apply to sports tournaments. So you can think of that, since the State House discusses it quite a bit in the month of March, as a March Madness exception. High school events, amateur or professional sports events where the participants are primarily under 18 years of age. On page 4, in subdivision 12, another key definition for the scope of the market: sports event. In general, it means any event in which 2 or more persons are participating in an athletic event. But this definition also expands that to expressly include horse racing and equestrian events.
No matter where they are.
Right. Yeah, this is potentially a global market for any one of these sporting events. You could think of the Olympics as well.
Oh, interesting. Okay.
Formula One.
Provided that
Desert racing.
the department approves it, and that's one of the procedures I'll talk about later, that the department has the authority to approve the categories of sporting events. And there's an interesting, I think it was a recent example, because I was listening to it recently, but the podcast may have been really old, where the WWE wrestling was attempting to get permission to have their wrestling matches be the subject of lawful wagers, either in Connecticut or Massachusetts. I can't remember which one.
Well, camel racing makes me think of
Well-
global betting opportunities.
Yeah, but those are not,
They are
As-
scripted matches. I don't
yeah.
wanna offend
Yeah, we don't want to go, I think they're less scripted than camel racing in Mongolia.
All right.
Global sports. Think big. Okay, so next, sports wagering has a huge number of different definitions.
The definition is meant to be essentially as expansive as possible. There is, for example, a non-exhaustive list in subdivision C that details what sports wagering includes.
Right.
All right, gonna move on to section 1302. which deals with the authority and duties of the department with respect to sports wagering. We're on page 5, by the way.
I'm sorry, did we talk about esports?
Esports are not expressly included.
Does that mean they're not included?
They are likely not included.
Sorry, what kind of sport?
Because
Like
sports.
video game sports? People who,
But what did you call them?
e-game, or
Esports.
e-gaming,
Yeah. Video game competitions.
which
And
are big.
Are those fantasy sport? I mean, what's the difference between esports and fantasy?
this would be, for example, the Overwatch League. It is a video game. You play competitive. It's a first-person shooter, and you play on teams of 6. And there's an entire league built around it. League of Legends, I think, is another big one.
Oh, yeah.
There are these, yeah. I'm trying to think of big games that I know of that people play competitive.
So this is a gray area?
But they have a governing body. They're regulated in some way by that governing body. And there are some states that permit wagering on esports.
So we haven't decided to go there yet.
You have not decided to go there yet expressly.
Okay, great.
So why are we not? Is it just because it's complicated that we haven't decided?
I don't know.
Okay, I'll ask.
I can't speak to the policy choices that were made. I can tell you
Okay.
that the Sports Betting Study Committee did hear specific testimony about the difficulty of regulating e-gaming from the commissioner from New Hampshire.
Okay,
So maybe we can hear from the commissioner at a point, because it will be task force and responsive. Let's keep going, and then Wendy, if you just make a note of that,
yeah,
we can hear why you chose to exclude.
I have a base question.
Yeah.
When we were looking at fantasy sports, gambling is prohibited in Vermont,
Right.
correct?
That is correct.
And we have defined the lottery as not gambling.
That is correct.
This, I assume, is also not gambling?
That is correct.
Huh.
This is, so as a later enacted, more specific provision, this is.
I like horse racing.
This is going to be controlling law, and you are developing a legal market. In addition, each one of the chapters you're talking about, including fantasy sports contests, has a section that says, notwithstanding the criminal prohibitions on wagering, this chapter, subchapter, what have you, is not subject to Title 13.
Sports wagering is not gambling,
It is not criminal
criminal.
wagering.
Or won't be once we pass this, if
We
we,
won't get to poker.
let's keep going.
Are we ready to move on?
Yeah.
Section 1302, again, authority and duties of the department. As you know, the department through this control model is going to be essentially the sole operator of the sportsbook, offerer of the sportsbook in the state through its agents. That's what this section sets up. In subsection B, you have the authority of the commissioner to negotiate a contract with a minimum of 2 up to 6 operators chosen through a competitive bidding process. There's a safeguard in subdivision 2 that states essentially that if there are unqualified applicants through the competitive bidding process, they can move that minimum of 2 down to 1 or 0 and potentially start the process over again. In subsection C, broadly, you have duties of the department with respect to sports wagering, global sports wagering in the state, age and identity verification, geolocation to make sure that wagers are placed within the state. In subdivision 5, you have Senator Clarkson's question about the self-exclusion program. We're on page 6, by the way.
Thank you, yes, I see.
So subdivision 5 contains the exclusion requirements. Essentially, the department is required to establish a statewide self-exclusion program that allows an individual to exclude themselves from wagering. Pause. There's a piece here about excluding joint bank accounts, which is the subject of the first instance of amendment. So
Okay, let's turn to our amendments.
In the underlying bill, this required the department to establish a process that would allow the holder of a joint bank account to exclude the account from all platforms in the state. The amendment would change that so that instead the duty of the department would be to establish procedures to exclude accounts based on joint financial responsibility. So what is the legal shift here? The shift is no longer that the bank account itself would be excluded from the wagering platforms. It is instead that the player account would be excluded based on a request from someone who has joint financial responsibility. So this is a little bit of a shift, and that the request is no longer going to be, I am a joint account holder, I do not want my account to be used, to I am a joint account holder, I do not want this other person who has access to my account to be allowed to wager. That's the shift.
So it's a higher,
It's a higher
there's more
standard.
responsibility on the,
The request is no longer self-directed. I don't want my bank account to be used.
It's
It was
actively,
now,
I want to exclude
I
someone
want to
else
exclude somebody else from wagering.
and,
That request is going to be mediated through a process established by the department under the amendment.
and is that the way other states do this?
No other state, to my knowledge, has a provision about joint
It's
financial
kind of
responsibility.
strange, it seems to me, that, you're having a person, a holder can exclude another person from all operator platforms, even those in which they are not a joint owner. Is that correct?
So the operator platforms are the apps. So the basis for the exclusion is that you're a joint holder of the account.
Yeah, I can't imagine you
But when
would,
we talk about all operator platforms, or operator platforms that are related to that particular account, or the individual who is the holder of a joint account, regardless of what platform he is on. Is this specific, in other words, to this particular account and this particular owner on that account? That's that. I can read this two different ways.
Although this sentence as amended no longer refers to all platforms for, all platforms in the state. Since it's built into the self-exclusion subsection, the department is going to likely have to make the determination about whether this is exclusion from all of the platforms in the state for this
or just
player account,
one
or just one.
two.
But it would be not excluding from all the platforms in the state that the department uses would allow that joint holder to evade the exclusion by just jumping to whatever other platform is available,
which isn't the intent.
which is not the intent of the exclusion subsection.
Should it be a separate section? Because this wouldn't be self-exclusion.
No, this is somebody you're fairly close to because you're sharing a bank account, being able to prohibit you from gambling at all.
With the joint money.
Exclude
You could
player
still-
accounts based on joint financial responsibilities. The player account is the account the individual has, not the bank account, it's the account that he has on the platform. And based on joint financial responsibilities, does this in effect charge the department with examining all the joint financial responsibilities that an individual has to make a determination as to whether or not the accounts are so intermingled that they should be excluded?
They're going to have to establish a process based on this.
Depending on process.
Well, they need a process because it could be a spouse, it could be a business partner.
It is
It could
like
be all
going to
kinds
have
of
to
things.
be a quasi judicial process.
Yeah.
Now, since it is no longer voluntary, it is.
How big a step will we need to do that?
Exclusion.
Why,
So I'd encourage, just in terms of time, let's have
We'll have to look at that.
let's do a mark on this and let's keep going. But I think this is allowing the department to set up a process to do this. So I think we definitely need a process to do this because I can see that it could be business partners, it could be a spouse, it could be possibly a child if you have joint, there are a lot of scenarios where you might have a joint
Right.
account and where, and I think this is a better revert. I like the, I appreciate the flipping of this So we can discuss this further, but let's keep moving as I'd love to get through the walkthrough at least before we then go further.
Subsection D, we're on page 7. This has a mechanism for the department to exclude specific events or types of wagers based on the request of a sports governing body or a college. So this could be the NFL, it could be UVM. If they reach out and say there's some reason that we don't want wagering on this particular event, they put that request into the department reviews and potentially excludes wagering on that event. This is an integrity tool here.
So, Nancy, I know we're in a hurry, but it's
Yeah.
important. So,
No,
so this could be done, I mean, this kind of thing would need to be done quickly, right? Because you might find out 2 days before or 1 day before. So devil's in the details on this, right? What do you do with people who've already bet? I guess you just give them their money back.
Well, that would be governed by requirements for house rules, which we might not have enough time to get into today, but I can send you descriptions of house rules. House rules are essentially the terms of the contract between the wagerer and the operator about, for example, when bets have to be voided and funds returned, or all of that would be governed by adopted house rules that the operator has.
So is it possible that bettors would lose their money?
no, because
Well, I don't know. That's, I'm not
You
assuming
would
anything.
you would have some sort of outside event
Yeah.
that is disrupting the contract between the parties,
Okay,
the agreement between the wagerer and the operator. So that doesn't, the cancellation of the event or the invalidation of this particular type of event, category of wager, doesn't mean that the wagerer is going to lose all of their funds.
So, wait, I guess I just love to go back to the beginning of this 7. One assumes that prohibited sports aren't even on the app. So how could they even wager?
So
I guess I'm a
Senator
little
Harrison's
confused.
question is, can this process interrupt some sort of wager that has already happened? If a wagerer has placed a bet 3 weeks in advance about some sort of game, and then 72 hours beforehand, there's some reason that the sports governing body says, hey, we have a problem, we need you to exclude wagering on this event. You have wagers that have been placed all the way up to that point.
Oh, okay.
That now need to be resolved. But again, all of the agreements between a wagerer and the operator, this is a agreement about a contingency happening. The contingency is the game. And you have something interrupting that so that the contingency can't happen for either party.
right.
So it's just canceled and void.
So the operator does refund the bet.
Yeah.
Okay,
It's,
all right, that was my,
Should-
okay, that was my question.
it's excellent. It's getting into the, the bones of sports wagering.
Yeah, because I would just have assumed that if you had a prohibited sport, it wouldn't be there at all.
Right, but this is, say they discover that some player may have been compromised.
Yeah.
And they say this is no longer a fair contest. I mean, it assumes that
Right.
sports are not influenced by money, and which is,
Right.
or
Somebody got.
which is
caught
kind of
being
a
paid off.
heavy duty assumption
Right.
anyway, but
Yeah.
but if someone's compromised and it would throw the game, for example, lose intentionally.
Right, and then it's pulled.
Yeah.
I see. I was just thinking like, well, you can't be betting on a high school sport because it's not going to be on the app.
Yeah, check out FIFA. I mean,
Yeah. no,
there are groups that are not held.
Subsection D
Okay.
is for legal, not prohibited events where there's a specific game or specific issue that has come up where the department would be excluding either the event or potentially a type of wager or limited. So it's not the prohibited events.
The event doesn't occur. There's a hurricane, there's a jet.
I am assuming you can get probably a lot of testimony on this based on the Bills Cincinnati Bengals game that was incomplete because of Hamlin having the
Right,
cardiac
having the
arrest.
heart attack.
Oh,
So you might be able to get robust testimony on what happens when the game is not
Well,
finished.
what did happen? I assume somebody was betting on it.
It was,
There were lots of
it was a
balls.
big game, so I would say that your assumption is likely correct.
Yeah.
So I
And
just
subsection-
want us to make sure we get through the walkthrough by 10. That's
Yeah,
all.
no, we can go down a lot of rabbit holes in this bill. So
Because we,
let's
you know,
get-
it's not even a matter of me voting on this. It's a matter of we now have to focus on budget issues. So, you know.
Right, no,
enough time.
we're right with you. Okay,
All right.
let's keep moving.
Down the rabbit hole, we're late for very important dates. Subsection E, this is the authority to approve categories of events and types of wagers by the department. This could be a general approval moving forward. It could be a specific approval from the department at the request of an operator. So the department has the authority under this bill to establish what is within the legal regulated market. Okay. Moving on to page 8, subsection G. This is going to be the subject of another amendment.
Right,
These are
Which we have
required
discussed.
contract provisions. This is amended. In the second instance of amendment, it eliminates what is currently subdivision 3 in the underlying bill and reduces it to 2 subdivisions. The first, the contracts would be required to have a provision that prohibits the use of sports wagering ads on products that are sold in Vermont and intended primarily for persons under 21. That's not changed. Subdivision 2, in the underlying bill, there was a cooperatively developed advertising plan that had to be included in the contract. Instead, here, the cooperatively developed clause is stricken so that the department has to ensure that an advertising plan is included in the contract. Quickly touching on section 1303, still on page 8. The department is granted rulemaking authority specifically for procedures. This is the same process that is used for the state lottery.
Right.
It is different from formal rules under the Administrative Procedures Act. By default, under general law, procedures do not have the force of law, but for the lottery and maybe one other specific instance, that is waived so that procedures can be adopted that do have the force of law. I can think of 2 instances. The Department of Liquor and Lottery is one, and the second is the Department of Corrections is allowed to adopt procedures that have the force of law. It is an expedited process. It is typically internally directed, and here it is going to govern the competitive bidding process and the regulation of the operators through contract and whatever these procedures are. There's some additional safeguards built into this section that are not in the Administrative Procedures Act. The Board of Liquor and Lottery is required to publish the proposals for the procedures, provide notice to operators, provide not less than 30 days for public comment, and hold not less than 2 public hearings. All of those are in addition to the underlying requirements of the Administrative Procedures Act. If we move on to page 9, what are these procedures going to govern? I'll move through the subdivisions to cover the categories of procedures that the department is required to adopt. Minimum computer system security, sports wagering system requirements that meet industry standards, minimum house rules. And Senator Harrison, you'll note that in subdivisions A through F, you have that the house rules have to have some requirements for these interruptions of the wager.
So that's like 6%.
Okay.
Subdivision 4, minimum accounting controls. Subdivision 5, minimum internal control standards, otherwise known as the mix. The mix and the minimum accounting controls are very similar. Minimum cash reserves. Subdivision 7, fairly exhaustive list of promotional play requirements that can be boiled down to whatever you advertise in your promotional play essentially has to be true. If you're going to advertise it as a free bet, it has to be free. You can't prohibit players from withdrawing their own funds that they've contributed along with promotional play. It's a lot of procedures and safeguards put into that subdivision 7. Section 1304 on page 11, revenues go to sports wagering fund, which we'll get to in a bit. That's going to be an enterprise fund, similar to liquor and lottery funds. Section 1305, I wanted to quickly note that there are Public Records Act exemptions built into this. They reflect general law, but you have a somewhat unique structure here in that a government agency is going to be running and cooperating with private enterprises in essentially a business. So you have the state acting in a business capacity here. So the existing Public Records Act exemptions are expressly built in here and cover a lot of, for example, financial business related records. And happy to go through the PRA in the future if you have any questions. Section 1306, that's the Title 13 exemption. It may not be necessary, but it's in here. Subchapter 2 now.
So that goes to Ann's question, right?
That's correct. Yes, I should have used my words instead of my very expressive eyebrows, which I shifted
You wanna-
Senator Cummings' direction
You did.
to say.
Right,
Title
right. This
13.
is
And I
the
missed that. So, so this is the exemption
to gambling.
Okay. All right. Subchapter 2, this is going to be largely the operator duties. In section 1320, we have the description of the competitive bidding process. So the operators will be selected through this process. In subsection A, in subdivisions 1 through 3, which are on page 13, you have the General Assembly's expression of intent to guide the bid process, maximizing state revenue, reducing the illegal market, protecting Vermonters from problem gambling. Those are the articulated standards guiding this process. In subsection B, you have a list of the minimum requirements for what operators have to provide to the department as part of the competitive bidding process. Remind you that the department, through its procedures, is going to be adopting more formal requirements for the competitive bidding process. This is your articulation of what minimally has to be provided as part of that process. Revenue estimates, subdivision 1, there's some more specific articulation there. Subdivision 2, individually branded websites. You can use the term skins, although it's potentially confusing, but how is your brand going to appear? How many different websites are you going to be using to sell this product? Subdivision 3, responsible gaming plans. Subdivision 4, your experience in other jurisdictions, aka where are you operating now? Subdivision 5, strategy for player acquisition. How are you going to convert people to this legal market, bring them in? Moving on to page 14, subdivision 6, the speed to market, the estimated time frame for implementing the applicant's operations. Subdivision 7, integrity systems. So what are your existing systems for integrity monitoring? And finally, subdivision 8, the applicant's plan for maximizing sustainable long-term revenue for the state, including a detailed market analysis.
So this is also being amended, the section C.
Yes, you got ahead of me.
Oh, sorry.
So subsection C establishes the operator fees. This is subject to an amendment that you'll find. It's the third instance amendment on page 2 of the document, track 1.1. This amends the fees for the instances where you have 2 through 6 potential operators. It's an increase from what was presented in the underlying bill. Happy to go through the numbers, but I think you already have.
We've actually discussed them with the commissioner earlier.
I think
I
that
believe.
might send it to finance.
Well, there's a revenue share here, so it's probably going. to
Yeah.
Oh, I think this is
Going to
going
finance,
to finance.
probably finance and approps very easily for the next week. Yeah.
There are appropriations in here too.
Oh, then
Yes,
it's going there too. Okay.
yes, the money committees will get it. They always do. Subsection D, this is the requirement that a revenue share be paid to the department. And it is set up here that the minimum revenue share that can be accepted by the department is 20%. All right, I'm gonna skip quite a bit now through go on to page 16 to quickly note there's a little bit of tension between section 1324 and section 1325 as it was amended by the House on the floor. So section 1324 gives the Board of Liquor and Lottery the discretionary authority to hear complaints about violations of sports wagering laws, contract terms, and to apply penalties or potentially to void the contract. So you have that authority where the commissioner might bring a complaint to the board to do those things. And then in section 1325, you have crimes and penalties. Subsection A governs the entire universe of potential people who offer sports wagering but aren't allowed to. So that was okay. It's separate from the department's operators. This is potentially the criminal organizations running illegal sports wagering. But in subsection B, you have criminal penalties that apply to the operators. So you have fines of $25,000, $75,000, and up to $150,000 for increasing violations that can be applied. And in subsection C, the department is granted express authority to terminate its contract with the operator and revoke the operator's privilege. Subsection C is probably going to be harmonized with the authority to bring contract violations or criminal violations before the board and terminate the contract. But you might want to look at the kind of split authority between what here would be a state's attorney bringing criminal fines before a court for violation of the chapter versus the department bringing a complaint before its Board of Liquor and Lottery to enforce
Can see
penalties.
Senator Sears wanting to take a look at this. We're setting criminal penalties. He doesn't like it.
Senator Clarkson, maybe just point, with Scott, just make sure he's seen it before it goes to the money committees as a pass by or whatever, pass through.
Yeah.
We're going to skip right past subchapter 3 because it is all existing provisions governing the fantasy sports contests. And what's happening here is it's moving from Title IX to the recreation and sports title where all of the wagering is housed.
So this is all existing language.
Correct. Nothing has changed. That was a point built in by the House Government Operations Committee.
But I mean, existing in statute.
That all exists in Title
Has
IX.
anyone gotten a report as to how fantasy sports is going?
You're anticipating section 2 of the bill,
Oh,
which hopefully
okay.
we'll get to within the next
In
hour.
my last pass through of this committee, we did fantasy sports.
Coming up. Okay, so we are now in the fantasy sports contest.
You're
I
absolutely
wonder if this is a good stopping point just because we're about to switch topics really mightily. So just a thought.
I think this is a great Patience anticipating.
Yeah.
I think this is a good spot on page 17 for us to take a break. I'm sorry to have to do that, but we'll meet here again at 11 o'clock, if that's okay.
You've got me booked.
Thank you.
Scott.
We love having you booked, and I apologize to our participants. And we are going to shift gears to back to housing, and then we will shift back to sports betting at 11. Thanks. We have a 3-minute break, committee. And
Can't even get the.
Whoa.
Where is this meeting? Zoom meeting
Okay,
or
so
are we
if you
going
have any
somewhere?
questions to call us.
more, what are we
And who
doing?
are not coming
Here. Jenny wants to stay in the committee, so we're doing
I don't want anyone to go very far because, it's a big hearing that we're doing. So,
We're not going very far. I mean,
okay, I just saw Wendy walk out. So I was worried that we're going to have.
Here.
Wendy is walking out because for an hour she's not
We're
here.
going to, we're just sitting.
No,
right
Wendy
here. We're sitting
Harrison.
right-
Oh, Wendy Harrison hit the loop.
Okay.
I think Some of us actually would love to hit
I'm
bullet.
gonna do the same.
Yeah, and Randy's gonna do this.
Okay.
You know, you might think, I can't